I don't
So
remember.
wait. Why is he on a boat?
Because it
they didn't. They
it had to be
couldn't have-
secret.
Yeah,
it had to be
secret.
Yeah,
And
it
the
had to-
only place where you can have a secret is on a boat?
On a boat. And
Liberal Currents presents Half the Answer with your hosts, Caitlin M. Green and Trent R. Nelson.
Well, you know that understanding a question is half of an answer, and happy days, well, they are not yet here. We're working on it, but generally speaking, they should be here. Happy days should be here again. Again, that is a work in progress. This is Half the Answer, and this is your host, Trent R. Nelson, but only your co-host, because we have Caitlin M. Green as well. And, well, you know, I'm a writer and an editor, and I yell about stuff on the camera all the time, as does Caitlin. She is a mom, editor, writer, linguist, headband wearer, Dark Miss Rachel. Yeah, absolutely. It's a good deal. Well, Caitlin, we just speak to the most interesting of people, like that old Looney Tunes cartoon. Well, who are we doing that with today? And what are we talking about?
Okay, yet again, I have to control my fan freak out energy and just be cool, Caitlin, because who we have here is the law dork himself, Chris Geidner, a journalist, a blogger, a law expert, and he's here to help us kind of understand the stuff that neither you nor I have the expertise, despite having done super well in mock trial in high school. That's about the limits of it for me. So, Chris, how are you?
hello. I think the how I'm doing on any day is summed up by what I have read and written so far that day. And so we're recording at noon on Tuesday, so I'm doing okay so far, but who's to say where we'll be by time people are listening to this or watching it.
Yes. Yes, every day is literally a winding road in post 2025 America. And well, we've seen across Minneapolis, it's not too good in terms of the violence there. But we have a whole bunch of fronts to cover as well. We've got some immigration stuff that we can talk about, and how that all relates to the Supreme Court of the United States. Something that Chris covers pretty frequently and regularly.
The Supreme Court, they're doing so good. We're so proud. Every day that we see a headline that says SCOTUS on it, we just grin and we smile and we think, oh, what a wonderful story I'm about to read about this venerable institution. Right, Chris?
Get out a nice cup of tea and
oh boy, what did they do this time? I bet it was so good.
What did Sam Alito have to say today?
I bet he protected my rights. I bet he did.
It's dark. It is dark. And I mean, just yesterday on top of it all, we had this report in the New York Times that since I'm sure coincidentally, 2 weeks after Trump won re-election, John Roberts has been making everybody at the court. They didn't say down to like cafeteria workers, but they said employees. So I don't know if it's the entire courthouse or just people in the justices' chambers sign NDAs to work at the court because they are so nervous about leaks in the aftermath of the Dobbs leak.
So the Supreme Court is CBS News. They're the same thing, basically.
I mean,
very wise.
I've been covering the court in person now since 2010, and have watched essentially sort of on two fronts as like what John Roberts, when if you remember, and you may not, and it's fine if you don't, and probably better for your health if you don't, but back when like John Roberts was like announced as the nominee and like was like at the White House with like his kids like pulling at his pants, like he was like the nice DC guy, like he was like law firm partner, institutionalist, like he was gonna protect the institutions. And like at the same time as like Democrats fighting back against John Roberts' nomination way at the time said like, wait, he was like in the Reagan Justice Department proposing some of the like craziest things that you've heard specifically about like the Voting Rights Act. And but like in like the early iteration of John Roberts, what we got was somebody who could do both. Like the GIF meme, why not both? Like John Roberts thought he could do both. Like he could be the institutionalist while day to day he could chip away at people's rights and implement his vision for the law. And then the court, he got a better court than he wanted. He got 6 Republican appointees. And as we most notably saw with Dobbs, the 5 who are more conservative than him said, no, we're not going to do this incrementally. We're just going to like go whole hog. And like back in that case, if you remember, he said like, couldn't we like do like a half step here? We don't need to overrule Roe in order to strike down this law. Or in order to uphold this Mississippi law. And the other 5 said, no, we can overturn Roe. And that's kind of the best understanding of the John Roberts that we've had for the past 4 years that led us up to this 2024 NDA. Like he's kind of a man who wanted to be known as a conservative institutionalist whose conservatism has just taken by far the front page.
He's I don't know, he's like the dog that caught the car, I guess. It's like, oh no, it turns out this thing's really big.
and like we still see, and there are times when you like when we see in opinions, when I see at arguments, like he's still trying to pull back at times, but they let it be known with Dobbs that like if the 5 of us want something, we're not going to wait for you. And
they don't have
like to be clear, there are times when he's like leading the charge when it is all 6, or there have even been times when it's 5-4 and it's Barrett who is joining the Democratic appointees dissenting. And so like it's not even that like he's the next to the left. Like it's just like there are these institutional moments where he would rather the court move slowly. And I think like honestly, I think that like Alito and Thomas in particular, and Gorsuch to a lesser degree, they watch Justice Ginsburg die, and they know that this 6-vote majority is like a bad night's sleep away from not being a 6-vote majority. Now, at this point, obviously, Trump is president, Republicans control the Senate, so it would be a little different. But I mean, they saw in real time both. I mean, honestly, both with Scalia's death, although it didn't turn out the way that Obama wanted at that time. But I mean, with both Scalia's death and Ginsburg's death, I think that all of the justices there, even maybe particularly so Barrett, they understand that, and Gorsuch, they understand that like as much as like political scientists might be writing about like, oh, this could be a conservative majority for 50 years or whatever, like they understand the reality that like people die.
Yeah.
That like the majority could change.
Right. They've forgotten an important medical fact about these like complete right-wing monsters, which is that their bodies are not being propelled by normal biological means, right? They're just held together by like, you know, spite and Big Macs. So I guess we just have them forever.
That's I mean, we've got Donald Trump walking around every day.
How is this still? I don't think his hands can get any scarier, right? Like, I think that it is truly not blood that is pumping through his body at this point.
I mean, I think when you think about the way that people look at the stories that came out of like the Kennedy White House decades later, like, I think those are going to pale in comparison to what we find out, like, what they're doing. I mean, just like by virtue of what we're seeing on his arms, like, I mean, he's hooked up to things probably for like an hour every night.
For sure. And like, or Reagan, right? Where it was like, oh, ages later, you're like, oh, actually, like he was truly a puppet for like his wife and her astrologer. Like that's all it was that was like operating the.
Yeah, no, I wrote a lot about the 25th Amendment back during the first Trump administration. And there is like this story when James Baker came in as chief of staff for Reagan, that that there was discussion. They sent this guy, I'm forgetting his first name, James Cannon, I think, who was like a longtime aide to Baker, who like went into the White House before Baker came in, and like Cannon came back and was like, we may need to invoke the 25th Amendment. Like people in the White House are saying this is something we should think about.
Of course.
There's a memo that was written that I've never been able to find. It's like my white whale. I've literally had people, James Baker's papers are at the University of Tennessee, where my brother is a professor. And like, I've actually had like people look through his papers. I talked to like Cannon's son or daughter about
like it's somewhere, it has to be somewhere.
But like the story is, it came out of actually Jane Mayer's book about the Reagan White House. I think I forget the name of it. I don't want to.
It's right there on my shelf. I don't think you
what's
can
it
see
called?
It.
The
Dark Money?
Of the Presidents? No.
Oh, the other one.
Like an old, like one of her early books.
Got it.
And like what happened is they basically had like a meeting in like the Roosevelt Room or something, the East Room, something where like Baker, Cannon, somebody else like sat down with Reagan, and like it was basically like a few white guys sat for a half hour and decided if the president could keep being president. And like Reagan was having an on day. And
that doesn't feel like how it should go.
They were like, no 25th Amendment. And it was never brought up again.
Yeah, he definitely needed to be 25th Amendmented.
It was
okay.
That's the history of America. Like that's what happens.
Right.
So, okay, let's imagine for a moment that like democracy is functioning and that things go the way they're supposed to go. How does the 25th Amendment how do we 25A that guy, the one who's in there now?
Well, the problem is the 25th Amendment is really awful. I mean, it's really good. Like it's really awful because nobody wanted to do it for the longest time. Like there's all these stories.
I noticed that 25 is a pretty high number, honestly.
Well, yeah, I mean, like there were discussions like back in Philadelphia about what to do. There were discussions as early as like those early guys who died. What was it? William Henry Harrison, who was the one who
died in
his
office.
inauguration. Was that
Henry
Harrison?
William Harrison died a little bit after his inauguration because
he got sick at the inauguration and then he died after.
And it was pouring rain. And
there were
he was like, I'm going to do it. I'm going to finish my speech.
There were questions then about like, is the vice president president? Is he
like this man
president?
Is in and out of consciousness?
No, when he's dead.
I see.
No, like literally
succession at all.
Even though we called him the vice president, there was literally a question about like, because I mean, the reason was if he's the acting president, you don't get a new vice president. And so like there was literally like we had to decide on the spot. It was like, well, so if the president dies, does he become president? The other question before you had the 25th Amendment is is there such a thing as the acting president? The Constitution says nothing about an acting president. And so if a president is sick, and the vice president becomes acting president, is the vice president just president? And did we kick the president out? Like, how does the president come back if he gets better? And so that's why, until we had the 25th Amendment, there were all these wild things. That's why you get the stuff about
Woodrow Wilson.
Woodrow Wilson and his wife basically taking care of the country and like moving his hand along things to sign it. Because we literally didn't have anything. And it wasn't until like you like had all of these things. There was who was it? Was it Garfield? There was somebody who had like cancer of the mouth, and
that's Grover Cleveland.
They literally like sent him out on a boat.
They did
to get dental. They like sent him out on a boat with a dentist to do the surgery. Yeah, for cancer. And and then I don't remember.
So wait. Why is he on a boat?
Because
it
had to be secret.
Yeah, it had to be secret.
Yeah, and the only place where you can have a secret is on a boat.
On a boat. And like, what was it? Who was it? Who maybe it was Cleveland, maybe it was Garfield. I think it was Garfield. After he was shot, he didn't die right away.
Oh, no, he didn't.
They sent him, they decided that the water would be good. And so they were sending him up to like a place by the water. And
my name is RFK Jr. and I endorse this message.
They literally built a railroad to get him there.
That was as he was dying.
They built a railroad.
Let's just urgently build a railroad.
Yeah. To move him because they couldn't move him in a car.
And famously, like the people ended up pushing his train car to like the finish of
the cabin.
To the railway, which is at the cabin. Yeah, like really.
Well, that's beautiful, actually.
I mean, and so we finally got around to like we should do something in writing, since we've been like just like messing around with this for 150 years. And so like the part of the 25th Amendment that we have implemented that people know about is the president writes a letter before he goes under anesthesia, and like the vice president takes over until he signs a second letter. Like that's the normal part. But part two, the part that's never been implemented, is the part that we keep talking about.
Removal.
And that's the one that like every
Against
writer
his will.
of every presidential TV show does at some point, and they all do it so wrong, and it makes me mad.
Well, here's your chance. Here's your chance, Chris.
I mean, the vice president has, like, whenever they talk, like, the vice president has to be for it. The vice president has to call the cabinet together.
Okay, well, fuck
this.
me then, I guess.
So yeah, basically. And then a majority of the cabinet has to vote for it.
Yeah.
And they can temporarily remove him. Effectively, they're doing a letter. But because that is such an extreme step, because it is essentially a constitutional coup, there is a provision that the president can go to Congress and say, they're wrong, I'm fine. And if that happens, and this is really the answer of why it's never been implemented, if the president does that, which in all times, except for when we'd all agree it it has to happen, like the president's going to challenge it, then takes a 2/3 vote of both chambers. So it's in order to confirm the cabinet's vote. And so it's essentially more difficult to invoke the 25th Amendment against the president's will than it is to impeach and remove a president and bar him from ever holding office again, because that only takes a majority of the House.
Which we also
haven't achieved. Yeah, great. Cool.
Yeah, and so like the 25th Amendment, like it's literally more difficult than impeaching and removing a president. So that's why we've never seen it. It is a very good threat. It's also the timing. Like the best time in American history when it should have been implemented was on January 6th.
Right.
Because you get like 5 days, if nothing else. Like you get him out of office immediately. Like Mike Pence could have gotten a majority of the cabinet on January 6th and gotten Trump out of office before the end of the day. And that, I think, would have then enabled Pelosi and McConnell to handle impeachment on a quick timeline before January 20th. We would live in a different world. That's Chris's little fanfic. But like that is, I think, the best.
That's flying cars, robot dogs
in American history for when we should have implemented Section 4 of the 25th Amendment. Because like by time Trump would have been able to force Congress to vote on letting him back in, they could have impeached and removed him.
Let's time travel.
Yeah, just live in that world for a minute and see what it does to your system.
I know that here at Half the Answer, the official line is if we had a time machine, we would go back and force them to do Reconstruction properly.
That is correct.
That would have helped. We probably
But if we can't go back that far, January 6th would be acceptable.
Yes.
Yeah, depending on the time limit of how far you can go back.
Right. Yeah. I'm not familiar with the science of our time machine that we definitely have at Liberal Currents, but
we're working on it.
Yeah. Sorry, you can never not get me going deep when the 25th Amendment is brought up.
No, that's good. I meant, okay, so what's the worst show that's like bungled at the worst?
They all just do. I mean, none of them get the vice president's role right. Almost none of them. Like they all like are like, well, like you get a vote. This was with your vote. Like, I'm like, calm down. I mean, I do think the West Wing probably got it the best because they never actually did that part. They just did the letter.
Yeah.
They were like, let's keep to what Like they had
He's
Lawrence
like,
O'Donnell.
no, I acknowledge that I'm
and
not
Lawrence
able to.
was like, let's just keep to the ones that they've actually implemented. Let's have, because that was the one where when like his daughter was kidnapped, he gave over the power to John Goodman. That was a wild time.
We could try that. We could just give John Goodman.
Well,
I think it couldn't be
but
worse.
that was
Is
a
that an
situation where there was no vice president. And so
Yeah.
when he had to, when he executed the 25th Amendment, he was giving it over to the Speaker of the House. And then they got it. This is why I do remember that I thought it was good. They made the Speaker resign. They said he had to resign from the House because he couldn't work for two branches of government.
See, John Goodman is definitely a speaker. Like, I'm glad that they like cast him in that role because he can't see him as vice president. Like he
was the speaker, and he had a dog that shed.
I forgot he was on that show. I feel bad.
It was a short time, but it was very good.
I think I watched the whole thing. Maybe I didn't.
The worst part is, I think he was modeled after a pre-scandal Denny Hastert.
Damn.
Like, because he was sort of this gruff, big, like, I'm just a real talking speaker who's become the president.
Oh, Dennis.
A thing you can always trust in a politician when they're really, like, posturing really hard about what a straight shooter they are. That always turns out to be right and true.
Never bad. I mean, speaking of speakers, let's go to today. Since we've been talking about past, like, let's talk about this. Am I allowed to swear here?
Fuck yeah.
Sure are.
This Mike Johnson bullshit today.
Trent.
Like, Mike Johnson, like, got up and was asked about, like, all of this stuff about immigration officers going into houses, and he talked about the fact that, like, all you need is administrative warrants signed by immigration judges who are so good, and that's sufficient. And the Democrats want to add this new process of a judicial warrant in order to enter a house. If they go in their house and lock the door, that's unworkable. Who do they think they are for this new standard? Like, it was honestly the most insane 2.5 minutes I've seen on video. Like, I mean, I don't want to be too crazy because obviously January was insane, but, like, we'll say for February so far. But, like,
we started off with a bang.
We did.
Like, administrative warrants don't even need to be signed by immigration judges who aren't even real judges. They're just executive branch employees. Like, immigration warrants can be signed by immigration officers. They don't even need to be signed by the executive branch's own faux judges. And so, like,
and I can sign my own doctor's note that says I don't have to go to gym class, right? Like,
so, like, he was wrong times 2 on that front, on the immigration, on the administrative warrant front. And then, like, it was, like, offensive on part 2, as, like, Trent even was, like, starting to react as I was just recounting it, because, like, the whole reason he was being asked the question is because acting ICE director Todd Lyons, in conjunction with somebody in DHS general counsel's office last spring, decided unilaterally in a secret memo that, like, they could change the Fourth Amendment, and that, like, we no longer needed a judicial warrant for immigration agents to effectuate removal orders in a person's private property, private dwelling. It like, that was the change. It was just revealed, like, 2 weeks ago, and Mike Johnson was like it, like, took gaslighting to a new level. Like, it was gaslighting the Constitution, like, if nothing else, since the 1980s. Like, like, whatever argument you may have, like even the Lyons memo essentially says we're going in a different direction from this 1980 Supreme Court decision, that we're
Just
now
'cause we
saying
said
that, like,
so.
well, I mean, their argument is actually, I would argue that even the Lyons memo would require an immigration judge to sign it, that like an immigration agent couldn't sign it. Like even the Lyons memo, I think, tries to like argue that because they report to different officials like DOJ versus DHS, that somehow, I mean, it's all bullshit under the unitary executive theory. Like if they all report to Donald Trump and Donald Trump is the final decider, it's not an independent officer if somebody in DOJ okays something in DHS. But like, at least if you have an immigration judge, like, that's kind of the way that the Lyons memo sort of suggests that it could be proper. But if it's literally just an immigration officer signing a 205, like administrative warrant, like there's no way that that is in fitting with any understanding for the past 45 years.
Literally just like, I checked with myself and I said it's okay for me to break down your door. Like,
literally.
No.
And again, I want to go back to a term that you used, gaslighting the Constitution, right? I mean, this is like literally basic stuff. This is like one of the reasons we didn't want to be part of.
I mean, this is that guy who's been doing the fanfic legal scholarship on birthright citizenship, Elon, whatever.
Vermin, right?
Yeah.
I mean,
like, I mean, you can't just like make up what the 4th or 14th Amendment mean. Like, it is what it is. Like,
it's unambiguous.
You can argue that, I mean, you can make an argument, and I think it's a losing argument under their own unitary executive theory that immigration judges are sufficiently independent of immigration officials that it counts as an independent officer reviewing the warrant. But to suggest that any administrative warrant is sufficient is just like false. So yeah, but that's what we're dealing with. I mean, that's the Speaker of the House, and that's why we're in the problem that we're in today. I mean, one of 20 reasons, but like it's something that it's really hard. Somebody, I forget who wrote it. It was probably Jamel Bowie, because everything he says is great.
Of course it is. But
like, somebody over the weekend noted, and I do think it is key, that so many members of the House have only come of age essentially since 2016 in a Trump world. And they don't understand, like, fundamentally what the point of our constitutional structure is. Like, they do not understand that they have a different role than the president. That the House has a different role than the Senate, that the Congress has a different role than the president, that all three of them have different roles than the Supreme Court. Like, they just do not understand that they are not, like, supposed to be helping each other. They can agree on things. But like I've written about it, like that. I think the thing that would most surprise the founders is, like, and I hate talking this way, but like, is truly how, like, unbelievably unmanly these men are. Like, they just would not understand how, like, they thought we've got these separated powers. Like, the great thing is men want to be in charge. Like, they are going to jealously guard their fiefdom. Like, they aren't going to let other branches encroach on their area. And like, this whole debate we've had over the past year with impoundment, like, that shouldn't have been like nonprofit healthcare organizations trying to enforce foreign aid. Like, that should have been Mike Johnson saying, we are going to shut you down if you don't carry out the spending bills that we passed. Like, it's truly like Mike Johnson is, I mean, and to a lesser extent, Thune, but like Mike Johnson is like absolutely a top 5, like why we have gotten so quickly, so far out of control over the past less than 13 months.
Yeah. Well, I think it's so inspiring how these modern men are challenging patriarchy by being cooperative the way that they always
they're
thought
collaborative.
Women.
Yeah.
Yeah, they're cooperative and they're collaborative, and that's really sweet. And
they're really emotional.
Oh my gosh. Well,
full
yeah.
of emotions. Yeah.
Well, the thing is that anger isn't an emotion, so that's why men are allowed to have
it. Oh, damn. Yeah. Damn.
And anger is best expressed in all caps posts on Truth Social after midnight.
Well, if you can just turn whatever feeling you're feeling into anger, then it becomes acceptable as a man to have it. And so whatever it is that you're feeling, just make it an angry feeling and you're good to go.
There you go. Well, you know, Chris, speaking of angry feelings, we've spoken a lot about the Supreme Court and how they're doing, which, as Caitlin noted, not great. As Chris noted, not great. But tell us how some of these federal judges have been responding to what the Justice Department has been giving them. It hasn't been fantastic for them, has it?
No, I mean, I think that like the true heroes of the past year are like threefold. It's like people standing up, it's lawyers who have been pushing back, and it's district court judges. And in a handful of occasions, appeals court judges, and in a couple of really special moments that are special episodes, the Supreme Court. I mean, we've got I feel like I got a sneak peek at what we were going to go through in Trump 2.0 when we started hearing these cases about the bans on gender affirming care for trans minors. When those started to be heard, like, remember back in 2020, there were no laws banning gender affirming care for trans minors, like none. Like 6 years ago, none. And when Arkansas and Alabama had the first two in 2021 and 2022, like you started to have this litigation. Then 2023 was the big deluge. The initial round of litigation, 6 or 7 opinions, including from 2 Trump appointees, were all unanimous from district courts that those bans were unconstitutional under U.S. Supreme Court precedent, under the 14th Amendment Equal Protection Clause, either or both based on sex discrimination or transgender status discrimination. That then went up to the appeals courts, and we got an opinion from Judge Jeff Sutton in July of that year that put one of those rulings on hold, a stay until they could decide the case. And that was sort of the tide shifting. The 11th Circuit then, which is a very conservative court down in Florida and some other southern states, issued a ruling blocking blocking a lower court ruling. Then the 6th Circuit issued it. Then it went up to the Supreme Court, and we got last year's Scrimetti ruling saying that those bans just aren't sex discrimination or transgender status discrimination by some little magic
cool,
trick
good to know
from John Roberts. But what we like, that is essentially what we then saw in 2025 and as to a lot of Trump actions, that looking at the case law that had been in place sometimes for decades regarding how the federal government worked with one another, how branches interacted, how agencies had to act, that the decisions were fairly obvious. And then you went up to the appeals courts, and a lot of times the appeals courts actually went along with it, because so much of this stuff, especially when you got to things like the Alien Enemies Act, when you got to him really Stephen Miller trying out the toolbox, that like even appeals courts were like, we're not, what are we doing here? But as we saw with like the immunity case, like then it gets up to the Supreme Court and they're like, well, we haven't thought about it before, really. And if you really think about it, maybe we should do this a little differently. And it will just happen to be in a way that Donald Trump likes.
So how does the nation reconcile, Chris, having a federal system of judges in which there is still seeming like reasonability and functionality, right? And then you get to the top tier and it is it's funky town. It's crazy. It's nuts. It's unhinged from what we're used to. How does that, what are we going to see in terms of reconciliation?
I mean, there are two things. One thing, a lot of the decisions from the Supreme Court thus far have still been preliminary, whether they're on the shadow docket, whether they're in the case of the way that they handled the birthright citizenship challenges, that they like first had those arguments over the scope, and we got that decision last year over nationwide injunctions, universal injunctions. Then it went back down and everybody was like, even under your new restricted standards, this is still blocked nationwide, either because of states having their interests involved or by way of class actions. And that's now going back up to the Supreme Court on the class action front. And then on some other ones, you had rulings that are like mixed. You had sort of the like slow roll to increasing the president's firing powers that led to like, well, we're gonna, doing like really a sign that they don't know what they're up against. They were like back last like May around Memorial Day, they were like, okay, so Donnie, we're going to let you fire basically anyone you want except the Fed. Don't mess with the Fed. And like a 5-year-old child being told not to touch the stove, Trump was like, well, obviously I'm going to mess with the Fed. You told me I couldn't do it. Sure. And like now the Supreme Court had to like separate it into these two separate arguments, one over the Federal Trade Commission firing of Slaughter, and that will probably have effect on a lot of those other cases. And then the separate arguments that we had in January over Lisa Cook's attempted firing from the Fed, that one didn't go as well. The tariffs arguments didn't go well for the administration, although we don't have an opinion. I don't think the birthright citizenship arguments are going to go well for the Trump administration. And I think what we're seeing is, again, to go back to the beginning discussion of John Roberts, we're seeing sort of like this, like, well, I thought I could half-ass this and things would like work themselves out. But now he's needing to draw lines, and we're gonna see some of those lines need to be drawn this term. In those three cases, we're going to see, are there any limits to the president, to Congress's ability? Like, let's like reframe this. This isn't about the president's ability to fire people. It's about Congress's ability when they are creating an agency that didn't exist. Like, agencies don't exist in the wild. When they create an agency that didn't exist, they give authorization to do things under law by that agency. If they could, like, the argument is pretty clear. If they could eliminate the agency altogether, shouldn't they be able to limit how the president can treat the person that is put in charge of that agency? And so we're going to get that answer this term between those two cases. We're going to get the answer with the tariffs case, essentially, of like, are statutes whatever the president says they mean? Because like, this is a statute. This would essentially be like upending the major questions doctrine and saying the major questions doctrine only exists when a Democrat is president, because there is, the word tariff isn't in the statute that he's using to justify these tariffs. And so like, that's that. And then if they would go his way on, I mean, the whole ball of wax is the birthright citizenship case. If they would go the administration's way on that, they're essentially saying that the Constitution is what the president says it is. And so I do think, like, in increasing order of alarming, we have three cases that they're going to have to take a stand. And that is why I do think what the district court judges are doing is so important, because it is letting, when they act, it lets the Supreme Court know that, like, where they're at. It lets them know, like, in a very real sense, like, will district court judges back them up when they tell Trump no? And they, I mean, when you watch like Judge Schultz out in Minnesota, I mean, like, this is like a conservative judge who I guarantee never thought that he was going to be doing what he's had to do over the past month. And yet he has, like, I know that there are people on the left who are like, why aren't people in jail? Why aren't contempt? Like, I think, like, district court judges, I think him, Judge Zenish, Judge Boasberg, in the two judges who dealt with the Alien Enemies Act, and Kilmar Abrego Garcia, Judge Ellis in Chicago, who was the one who was like calling Bovino to account. I think, like, it's really important to understand that those judges, some of the judges who dealt with the early Alien Enemies Act cases, the judges who dealt with the initial birthright citizenship challenge cases, like, they did a very good job of not only letting the higher courts know that they were there to do their job, but letting the administration know that they were there to do their job, and bluntly letting the public know that they would do their job regardless of what the Supreme Court did. After one of the shadow docket rulings allowing mass firings, there was it was over an injunction or TRO, I forget which, issued by Judge Susan Ilston in San Francisco. And she basically went back to the drawing board, looked at that shadow docket ruling, went no further than the justices were willing to put on the record, willing to give justification for, and said, here's what they allowed me to still consider in your challenge. They only addressed this. They only addressed the mass firing. They didn't address any individual RIF plans from agencies. And so I am still going to allow you to bring challenges to me for any individual RIF that you can find or get turned over in discovery that's been issued. And I think that is judges learning the things that we've seen with judges making DOJ, DHS, state submit status reports within 24 hours, 48 hours of a ruling. The responding to show cause orders by saying, like, you need to provide evidence within 2 days of this, or I'm going to hold you in contempt. Like, when people say, like, when Judge Schultz issued that ruling that listed the 70 cases that he had seen potential claims from judges that there might have been orders being violated. People got very upset that part of his order said that I was calling Todd Lyons. He was calling Todd Lyons to come to court on Friday, unless the person at the center of this case was released per the order. And then they were all mad that he had that exception, and then that they released the guy. And so the contempt hearing was canceled.
Right.
That honestly makes me want to cry, because you're kind of missing the point. Like, that was a habeas case that was filed to get a man out of detention who was, his lawyers argued, being improperly detained. And Judge Schultz got him out of detention. Right. And if you're mad at that, go home, do a meditation, and come back. Because that's the point. That is a district court judge doing their job. And bluntly, having that list of cases was literally a little present for reporters. Here are the cases that I found that you should look into. And I work alone. I don't have a whole team. I figured, and I'm a little upset that I haven't seen it. I thought the New York Times or Wall Street Journal or Post or somebody was going to have here's what happened in the 70 cases, with one of their fancy New York Times scrolling image.
The ones that you can move. Yeah.
Yeah.
Those are fun. We all like those.
I haven't seen it. I looked through
more of those.
I looked through a handful of them, and what I saw in a bunch of them, and some of them were before, it was good for him for listing as many as he did, but a bunch of them after the order that he issued, after the orders that he cited that said that there might be noncompliance, in almost all of them that I looked at, 2 days later, there was a status report that's sealed or not available on Pacer by the Department of Justice. And I presume that in almost all of them, since there were no filings after it, that those were, this person has been released. And so what that tells me, the reason it's a weird, there's on Pacer remote court access. Habeas cases are by default they're not sealed, but they're not available remotely because there can be private information in them. You can get them like if it's in a normal time and like the only people who would care about a habeas case in Minnesota are people in Minnesota, like you can go to the courthouse and a reporter can look at all the documents, but they're not put online for mass distribution. And so like we didn't see them. But like that, so that's what I presume. And so like I do think like that's been the example that's been floating around over the past week of like they're in non-compliance, blah blah blah. Well, like that's the way the court system works. If you think that there's non-compliance, you file a motion as a lawyer for show cause, where you're saying we think they should be held in contempt. And the judge then issues an order to show cause where he says respond by a certain time. And then they respond. Now, what, like, I'm, woe be it from me to defend DOJ, DHS, ICPB. Like, but like, I think the reality is that there are hundreds, if not more, of these cases that have been brought in Minnesota because of the lawless way that Kavanaugh stops have allowed them to arrest anybody. And so there are a lot of habeas cases that are resulting in habeas grants, much more than you would have had in the past. And you've got a combination of poorly trained ICE and CPB people who like are filling out forms wrong, don't know how to fill them out, are doing bad things and like potentially like filling out forms incorrectly on purpose, whatever. Like there are both good and bad, incompetent, the level between incompetence and and then you have this Minnesota U.S. Attorney's Office losing employees every day. And like, so like there are like those 70 cases, like, let's point to them. This administration is bad. They like need to be in control. It's a reason for the Democrats to not fund any DHS bill that does anything like what the Republicans want. But like, I think like if you actually go case by case through those 70 cases, what you're going to see is very bad situations of arrest that shouldn't have happened in the first place in a lot of these cases that were authorized by the Supreme Court with the Perdomo decision. And then poorly handled cases / illegally handled cases by DHS and ICE, followed by overwhelmed DOJ having to defend all these cases. Like my understanding is that essentially one lawyer who is now leaving the office was leading all of those. This Anna Voss. And there was a report in the Star Tribune yesterday that she's one of the newest lawyers leaving. And there was a report in Mother Jones on Friday that went into more detail about the office being debilitated that didn't name Anna, but did mention she's the civil chief and said that she's leaving.
And it's not just here. It's not just in Minnesota. Obviously, we know what's happening there in the violence and lawlessness from Border Patrol and ICE continuously unfurling is beyond comprehension for some folks. But prosecutors are leaving
pointing guns at people today.
Absolutely, absolutely.
Out in the street.
Absolutely. Be safe out there. Loons together strong. It is worth, though, considering that it's not just in Minnesota. I mean, we've seen federal prosecutors leave in Tennessee and other places What does
Well,
that?
Tennessee because of Abrego Garcia, Eastern District of Virginia because of the James and Comey stuff, and probably wherever they're doing the shift stuff, in Southern District of New York when they did the Eric Adams stuff. I mean, almost all of these situations that we know about are when there were specific efforts to either end prosecutions or bring prosecutions that people who had been longtime employees felt were improper. We've also seen, obviously these questions are raised anytime that they send either ICPB, National Guard, Marines into a city, because then there's litigation. We learned a lot early on when they did the original LA deployment, some of the first cases. We learned a lot in Portland. We learned a ton. And I think, again, like Judge Sarah Ellis, she had the press and protesters case in Chicago, and she's the one who got the deposition of Bovino, multi-day deposition. She, like, people focus on the fact that, like, the Seventh Circuit, again, this is another one of those, like, people focused on the fact that the Seventh Circuit stayed her order for Bovino to report to court daily. But she got like that deposition on the record, that 2-day deposition, like that. I think truly it very much undermined him when they tried to go to Charlotte and New Orleans immediately afterwards. And I think it did put him in a precarious position that ultimately led to his ouster in Minnesota. Like these, like I think it's very easy to get mad that any one step doesn't succeed. I get it, and every one step should succeed. But if we actually want to win, I think it is important to understand that process, that everybody, like, if you focused on the loss in LA originally, we'd be done. Why didn't we just let the National Guard go everywhere? No. They learned from what happened in LA. And when the Portland case was brought, they made sure they had a crisp, clear case. They brought it when there was basically no protest going on. They brought it when there was no violence. They literally waited until everything at the facility was relatively calm. And Judge Emmerhoff, was she a Trump appointee? She was definitely a Republican appointee. She might have even been a Trump appointee. Like, she just really like slammed them. Yeah. And like that then did lay out the blueprint that was used in Chicago, even though you then had like a bad Ninth Circuit panel that initially had some issues with the way that things were going to run in Portland. It is a step-by-step learning. And that's actually one of the things that I've most been impressed with advocates over the past year, both activist ground and lawyer ground, is that like there is this iterative learning city to city. Yes. That like people keep focusing on like ICE is getting more aggressive. I think the activists know that's not true. There are obviously some things that are more aggressive, but the tactics were being used and people knew it as they went in. Like I saw like there was like this reporting out of Maine that they were going to people's houses. And I'm like, well, no, they've been going to people's houses. like that absolutely has been happening. The fact that people knew to immediately be recording and to have everything on, like that might've been new, but that was the iterative learning. And right. I think that like it eventually does, I think, and this is like, the good note, and I talked about like those small golden moments. Like, I mean, that is what led to what we eventually got in the end of December from the Supreme Court, where they did say like, no, we're not going along with you. And I think we've seen no new National Guard deployment since then. And I think that even though they're still fighting it, like blah blah blah, like, I mean, they let it be known that like, hey buddy, like you
can't do that.
So okay, not only did you not do it, but you didn't do it carefully.
Right.
Yeah. Let me make sure the facts are right on Karen Immergut, which is that she was appointed district court for Oregon by Trump.
Okay.
And
yeah,
it was,
she was a
U.S. attorney for Oregon by Bush. So
right.
Wow.
Yeah, but she's been around a long time.
She's been around a long time, and I mean, like she like I do think there's an interesting, like I'm really just thinking about it now. But I'm giving away this content for free. This might become something in the future. But like
exclusive.
I do think there's an element to the fact that so many, until Biden really, so many judges are former U.S. attorneys, or at least former AUSAs. And they know, especially when it comes to the Republicans appointees, like basically all Republican appointees either were big law firm partners or were prosecutors. And like, they know how these offices should be operating. And I do think they get, like, it's that, like, the way, like, I haven't lived in Ohio since 2009, but like, do I get irrationally mad at anything that JD Vance does because he was Ohio's senator for 2 minutes?
Oh, listen. Yes. I get mad about stuff that happens in Oklahoma, and I moved away from there when I was 6. Like, I get it,
Like, and so, like, I do think there is that element of, like, these judges are like, who probably have an incorrectly idealized view of the U.S. Attorney's Office. But in this situation, it's working in our favor because they're like, what are you doing to our, like, golden, like, when you look at some of those opinions that were written in the Eastern District of Virginia, like they're mad. Like, when you look at like, you do have some, like, Democrat, like, people were pointing to, like, Judge Reyes's opinion in DC last night, blocking TPS from Haiti, the Haiti TPS ending. Like, that was, like, fire, but, like, I've been in Judge Reyes's courtroom. She also overheard Talbot, the challenge to ending the trans-military service in DC, the DC case. And she's a firecracker. Like, let's be clear. Like, she's going to not hide how she's feeling about a case.
How do we feel about these decisions that are being written, knowing that they're gonna get posted on, social media, and people are
you're talking about the
fire emoji case, under it, like
the case about Liam Ramos, where he like, you know what? Good.
Yeah.
Like, like, do I want every opinion to be that? No. And like, I do think, when you look at, over the weekend, you had too many judges. The Minnesota 10th Amendment decision, rejecting Minnesota's 10th Amendment case that this was that Operation Metro Surge is infringing on their sovereignty.
Right.
Like that was a Biden appointee, and but it was a very careful decision. It was a decision that talked about what it wasn't deciding, talked about the fact that it wasn't ruling on the lawfulness of any actions, that it was ruling on whether or not this argument to stop it is successful, which is something very different. And like she kept pointing to, speaking of press and protesters case, she kept pointing to the fact that another decision had been blocked by the Eighth Circuit, which is a very conservative federal appeals court. There are 11 active judges. 10 of them are Republican appointees.
Woof.
And she kept out of the decision, but everybody reporting on it knew, like, it was her decision that was stayed. Like,
Right.
so literally the Eighth Circuit had just said, in a case that only addressed the implications of the treatment of protesters and observers' First and Fourth Amendment rights, that she had gone too far. She had gone overbroad. She had swept in too many people. She had done too much. And then she was being asked to rule that the 10th Amendment should be implemented, it should be enforced in a way that it had never been enforced, in a more broad way than had ever been enforced, to stop the entirety of Operation Metro Surge. Like, could have she done it? There are arguments, yes. I think there was one area of her argument about coercion after Pam Bondi's weekend letter that basically said, turn over voter rolls,
right.
your TANF data or whatever, and get rid of sanctuary cities, and we'll stop Operation Metro Surge. That I think I think her likelihood of success on the merits analysis was a little off there. But like, as to the rest of her decision, like, I definitely don't think she got the Eighth Circuit's analysis wrong. And like, we got like this well-reasoned decision. And I think that was important. On over the weekend, the same day, do I think it was important for the judge to say, essentially, what the hell are you doing? What is law? How is there a 5-year-old bringing a habeas case to my court in Texas?
Right.
Yeah, why has this happened?
In Minnesota a week and a half ago. Like, what are you possibly doing? Yeah.
So, okay, I have more questions about the Liam Ramos case in terms of like, how do we get more kids out of there? You know, like, so I am in the Portland area. We are concerned about Diana Crespo. She's 7 years old. She's from Venezuela. She survived a trip on foot through the jungle to get here. And she's supposed to be at elementary school right now, right? She's supposed to be in her second grade classroom. She's in Dilley, where there's a measles outbreak now. What do we do about all these families?
Yeah, there's this combination of things that the administration is doing. What they keep doing is basically like, if we put several steps on top of each other, we can take this action legally. And so what they do is essentially they do things like, we interpret the big dispute in Minnesota is over which law applies to whether people can be detained after arrest. And like, essentially a lot of this comes down to an argument that people just detained with asylum claims that haven't been adjudicated should be processed under this law instead of this law. And this one law allows detention, pending adjudication. The other law requires a bond hearing. And like the first argument is they shouldn't be detained. Like that the agreement that they had reached with the government is that they are not a flight risk, they are not a danger to their community, et cetera. All of the standards, and like they have, while their application is pending, they're allowed out, they report to ICE regularly, they do their check-ins, they are fine. They first say like, well, that was a voluntary agreement. That's not a legally binding agreement. We can change that at any time. So first they change that. Then they say, we think the second law applies here, not the first. And so under that, we do that. And we think that our timing on the bond hearing can be after we resolve your claim. And like, because the bond hearing can be up to any reasonable time. And we say a reasonable time is 2 months because we're overwhelmed at Dilley with people coming in. But then separate on another track, they've decided that they can fast track decisions on asylum claims and essentially rule quickly on asylum claims. And because they fired all of the immigration judges who are going to rule with them, and because any decision against them can be appealed to the BIA, which reports directly to the Attorney General, and can be any decision of the BIA can be overturned at will by the Attorney General, which is the whole reason why the whole thing of calling them courts is like one of Chris Geidner's long-term goals is like to change those names, like to the extent we keep those bodies. They are not immigration judges, and the Board of Immigration Appeals like should not be thought of as a court by anyone. And a reporter who says that is like gone. But because of that, you get rulings on asylum that then can only be appealed through that process, which is a totally separate process from the bond hearing. And then you get in a situation that's similar to, slightly different because different laws are involved, but like the sort of Russian novelist style maze that like Mahmoud Khalil is in. That Ozturk is in, where you have like, we're going to make them go through like multi-step process on multiple sides. Yeah. And all of them have different standards and require different legal analysis. And all of the ones on this side, until you get to a federal appeals court, are going to be ruled on by essentially members of the Trump administration.
I've already read this book. It's called The Trial, and it is by Franz Kafka. And I mean, just absolutely absurd.
I feel like we're stuck in this like happy universe where we have to talk about Kafka and Orwell and stuff like we're 8th graders. Like,
well, the first answer is, and this is the reason why, like the Saturday quick, harsh, aggressive, slightly performative.
But you know what? Performativity.
Well, no. Like why it was needed is that he knew that attention would be paid to this order, and like you didn't even see an appeal. Like this administration didn't.
It was a total chaos.
That's something that I've written a lot about. Is it's I mean, on two fronts. Like one, like people don't know how many times the Trump administration is losing, because when the Trump administration loses, and this is actually a funny reality of the another horrible way in the world in which we lose, because the lawyers and agencies don't want Trump to know about their losses. They literally, like, when they lose and they know they lost, and it's not a case that like a lot of attention is going to be paid regardless, like they won't appeal. Or like what they've done in a lot of cases where like they know Trump won't allow them to lose, like they will literally slow walk the case. Like the federal government has 60 days to appeal a district court loss. They will literally file their notice of appeal on day 59.
Straight death of Stalin stuff.
Isn't even the appeal. Like it's just like preserving their right.
We will be appealing.
They get up to the appeals court. This, like, most notably, I've enjoyed mocking it, happened in the law firm cases. Those EOs that he issued attacking Perkins Coie and Geidner and Block and
100 years ago, right? Okay, right.
The four firms that challenged all won a mixture, again, 2 and 2, Democratic appointee, Republican appointee. They waited till day 59 on all of them to notice appeal. They never filed for a stay pending appeal. They never went to the Supreme Court on the shadow docket. They got up to the DC circuit. They literally waited. It's hilarious in light of like what they do and everything else. They waited for the DC circuit to note that all 4 of these cases had been filed. The DC circuit issued a sua sponte order saying, hey guys, how are we going to treat these 4 cases? Are they going to be consolidated? What's the timeline going to be? How are we going to do it?
Right.
Then, even with that deadline, DOJ twice filed notices to extend the deadline to file the agreement for what the timeline would be for those cases. We're now in a situation where, like, we're not even going to get an oral argument on those cases until maybe the summer. I think the earliest would be like May. At this point, there's now a secondary fight over whether an appeal, Mark Zaid, who's a lawyer who does whistleblower complaints, he also had his security clearance taken individually, and he sued as a one-off just about that one security clearance being taken. That, like, I understand, like, DOJ think that's a better case. It's not like, it doesn't look as like obviously retributive and First Amendment violating when you like say like the entire law firm is going to lose their security cases. And so they probably think that's their best case. And so they tried to pull this sneaky move where they went to the DC circuit. After pulling all this bullshit with the law firm cases, they filed a motion to expedite the appeal of Zaid's appeal.
Yeah, let's hurry this one up. Okay.
Ironically, in a situation of like things happening that just wouldn't have happened in the past, the DC circuit, they didn't issue an order denying it, but they issued a ruling for the timeline for Zaid's case that is virtually the same as what the rules set out.
Right.
Like, I think they cut off like 3 days. Like DOJ was literally asking for like 10-day, 3-day turnaround. And like the normal turnaround is like 45, 30, 20. And they gave a timeline of like 30, 20. And so like they basically denied the request. Like DOJ got a request to expedite an appeal denied because it was so like, I mean, it was like almost like, I don't know if something can be bad faith on its face when it's technically like an unrelated, like it was just so bad. But like you get that sort of stuff. And so like when you see them, like I think like it is like we already had one dog metaphor about the dog that caught the car. Like I think the dog that didn't bark is really important to notice in this administration. Like when they don't appeal something, when they don't challenge something, it's when they do slow walk something. Like the joke, like some lawyer on Twitter, on Blue Sky was like the DOJ lawyers' goals is to not have to file a cert petition in the law firm cases until sometime after January 20th, 2029.
Right. Well, that tracks. Again, the very death of Stalin. We were just talking about this over the holiday season. Anything to placate the benevolent, wonderful leader of the state. Well, Chris Geidner, we could literally sit here with you for hours upon hours upon hours. You are the law dork, and it is absolutely brilliant. I have a question. I mean, we're not done quite yet, but I do have a question. Harking back to the beginning of our chat, we spoke about the Supreme Court and Justice John Roberts, and you mentioned, that the courts are just one bad evening from not being such a majority as we have right now. But the midterms are also coming up. And I wonder how that is playing. And of course, I'm asking you to be prognosticator and a bit of a seer. How do you think that's playing in the minds of folks who remember the Scalia episode and how that was handled by Mitch the Grim Reaper McConnell, as he loves to refer to himself as, like he's some type of biker?
God, he's so tough. The thing about him is that he's both cool and tough.
He's so tough.
I think about him, those are the two first.
Yeah, just a badass,
There are so many adjectives that
I think of a turtle, to be honest.
But
yeah, he would prefer that you not do that. Don't. Please don't mention turtles.
There's two things. I mean, like there's the very serious, very real, like, what the hell is Tulsi Gabbard doing? What happened in Georgia? Why were voting machines taken? How were they taken? The New York Times follow-up reporting that like Trump was literally on the phone with the agents who carried out the raid the next day, like via a call from Tulsi Gabbard to him via cell phone. Like that is like 10 stories in and of itself.
Right.
Like in any other era, like why is the director of national intelligence there? Like, why was there a raid? Why were ballots taken? Why was there not a complete uproar the next day from every official in the state? Like, why are we not marching into court that day? Like, now I will say it is entirely possible that there is like some behind the scenes court fight going on, because a lot of the times these like fights over warrants happen secretly until we know. Like as we saw, like obviously the warrant being served on the Washington Post reporter, like we knew about that day, but like, and we presumed it was being challenged, but I don't think we knew where the challenge was and what some of the documents that were filed and it were until like that was unsealed. I think like yesterday or the day before. But like, so you've got that. You've got the like very real like questions about like what is going on in their mind. You've got this crazy interview with Trump about federalizing elections, like which
Right.
you do.
No.
You've got like, I think that it is notable that Judge Catelli's permanent injunction barring portions of Trump's original executive order relating to elections did come out on Friday night right after the Georgia raid. Like she had already issued a preliminary injunction, so it wasn't like she changed the facts by issuing the permanent injunction. But I do think it's notable. Like, I mean, she is a judge who has overseen, like, go check her Wikipedia. Like, she's had many high profile cases. She knows what she's doing. And like, I don't think it's chance that like she issued a lengthy ruling reminding people, like literally one of the first, if it wasn't the first page, it was the second page of a ruling, literally had a sentence that was like, the president has no role in federal elections. like not chance.
Yep.
So you've got that legal side that I think is alarming, because like none of it should be happening. But like, I do think that there are limits to it. And I do think that people have mostly been in control of that. But I do think like even Rick Hasson, election law lawyer, UCLA, very smart, very calm, relatively speaking, probably to all three of us here.
Well, okay, fine.
Is like, he saw that as like a very alarming sign. So I think like sure. We don't want to ignore any of that. We need to pay attention to that. We need to make sure all those protections are in place. We need to make sure any court action related to that is happening, is being done, is established well ahead of the elections. Mm-hmm. On the other side, the not rare good news, because there is a lot of good news out there, but like, there's a reality. Like we're now too far removed from the quote, so I'm not even going to pretend it. But we exist in the context of all that existed before us and after.
Coconut trees,
Vice
right,
President Harris. Yeah. Mm-hmm. And the latest coconut tree that we fell out of was Texas State Senate District 9, and right. Like a 30-point swing in Texas is not made up.
Right.
Yeah. Like I'm an elections person because in a former life, I worked on a few elections. I'm an elections person because I have a poli-sci degree. I'm an elections person because I covered politics for a decade. But like, I'm mainly a legal person now. Like, I don't even know some of the, like, I definitely don't know many of the House people at this point. There are senators sometimes that I'm like, you're fucking with me. Like, that's not a senator. Who is that? Like, what are you talking about? Like,
you're just saying
there's
names
like,
now.
There's like the junior senator in Kansas. Like, I was like, no, come on. But like where we're at, like some of the actual people who do know what's going on, like they were saying like those results were like not a sign of a wave. They were a sign of like an FDR era wave. Right. Like they were not a midterm wave that mm-hmm. we've come to learn of it. They were not even like Newt Gingrich revolution wave. Like,
yeah. We're
talking like all of the apple carts are upset, not just like shifting majorities. And right. I think it's important to understand, and I think it's important for like Democrats in office, but I think it's important for people out of office. And I think it's important for potential candidates. And I think it's important for activists. And I think it's important for judges who operate in this political system to understand like what the reality is, and that like you're not out on a ledge or out on a weak branch when you do what Judge Fury, I think is his name, out in Texas did over the weekend. Like you are actually like both correctly interpreting the law and Constitution and like doing what people expect a judge to be doing right now.
So are we potentially, in your esteemed view, are we potentially nearing a sort of precipice where if somebody like, say, Samuel Alito or Clarence Thomas, if they don't decide to step down, that there may not be a safe time for their political majority?
Oh yeah, I absolutely think that, like, if I mean, I don't know that Alito and Thomas's clerks watch this, and I don't know
I would
if
have to guess no.
if Ginny and Martha Ann are watching it.
Hi, Jenny.
But like,
It's
I
late,
don't
go to
want
bed.
it. I don't want them to. So turn it off. This is bad. This is, I'm going to say stupid things that you shouldn't listen to.
I think they're gone.
They're gone. Okay. They're gone. Like, yeah, if they don't retire, they're stupid.
Right.
Like, if at least one of them doesn't retire this year,
Now.
like
Yeah.
it would be dumb, like dumb. Like, I mean, I know, like, I mean, and what happens, I get it. What happens is partially true. Like, if you have been on the Supreme Court for more than a decade, you are the only one who can do your job.
Mhm.
Your job.
Sure.
Because what your job is over time becomes more than just being a justice. You literally become the person in America who is responsible for what happens to the law in 2 or 3 areas. Like, this is the thing that we don't,
Yeah.
like, I mean, sometimes like lawyers will talk about and stuff, but like, basically, like, over time, like, justice is like, they get a few paths that, like, this is their
they kind
area.
of specialize, right?
And like, I mean, to his credit, like, just one of those with Justice Scalia, in addition to all of the crazy ones, was like reinvigorating the jury process in America and making clear that, like, the jury right is not just like dead letter law. It's not just hypothetical. And he put in place protections that really made it so that the jury right was more clearly protected. And like, he just wrote all of them. We've seen that. And I think it's very interesting when it comes to things like the 4-4 split over the Oklahoma, the religious schools, the religious charter schools case that split because Barrett recused. All of those earlier decisions were Robert's decisions. He has been sort of crafting the way the law is moving on that. And so, like, he really, assuming that another case comes up where she's not recused, like, he's almost certainly going to be writing the decision and has controlled that. And so, like, I do think there is this element that gets in once justices have been on the court. And like, obviously, like, Robert, Thomas and Alito have been on the court much longer than 10 years. Thomas since the 90s and Alito now for almost 20 years. They really do have an element of thinking like there is no one else who can do my job. But like, as again, they both watched their colleagues die in office, not at a time of their own choosing. Like, it wasn't even like they knew they were going to die and stayed. Like, I think it was much more like just happen. I mean, obviously, like, Justice Ginsburg had the cancer recurrence and knew that she had problems, but like, it was obviously not of her choosing, and she wanted to make it through. And so I think that they have seen that. And I mean, now, like, especially as to Alito, he certainly has the ego that would allow him to say, I'm different than them. I'm younger. I'm healthier. I'll make it. In some ways, I think it is interesting because I think Thomas is more happy continuing to be on the bench until death. I think Alito would like to retire. I think there have been a handful of stories from people who are much more likely to get access to Alito's thinking than me, who have suggested as much. And so I do think that in some ways, Alito's the most likely to retire. And I think that would lead to an all out. I mean, it's the free for all that we've been seeing. I mean, there are so many appeals court judges who are just blatantly auditioning to be the nominee. They're trying to out crazy each other,
right. Because we're not the first
Trump.
People to think that it might be important for him to get out now.
Yeah. And so, but they've been trying since, James Ho in the Fifth Circuit, Kyle Duncan in the Fifth Circuit, Van Dyke in the Ninth Circuit. They've all been trying to make it clear that they're the winner.
Judge
Judge
Kyle would be such a lame judge.
Judge Kyle. In some way, the funny thing is James Ho is horrible and horrific, but Kyle Duncan actually comes purely, fully from utter far right religious crazyville in a way that truly frightens me. And he's young. Ho is too, but Duncan is young. And so I think I would be shocked if we don't see a retirement this year. I also think in a way it does do some weird things because this is an unusual environment where it actually could, especially depending on who the nominee is and presuming they will be confirmed, it could be a way to truly, one, radicalize the Democratic position on the courts even further than it has been since Dobbs, and two, just utterly radicalized turnout. Because in some ways, it works backwards because if they actually get a nominee through, what are they voting for? For the eventual retirement of Thomas? Okay. But at that point, they've got 4 young justices and 2 other Republican appointees. I get, somebody in a spin room is going to make the argument, we keep the Republican majority so that Thomas can retire and we can have a 5 Trump appointee court. That's what they'll do. That would be the ads, but it's a lot harder to amp up as opposed to this is what the Senate majority just did. Because they'll all be needed. If Collins and Murkowski vote no, all of the other Republicans would be needed. And so that means everybody up for re-election would be needed. And so they're all going to have voted yes. I do. I think, could that make the difference in a Texas Senate race? Yeah. Could that make a difference in Florida? Yeah.
Chris Geidner, you are the person that we call upon when we need all of the information, and what a treasure trove of information you have provided us with today, sir. We appreciate you so much. Won't you come back on and do her again with us sometime?
Yes.
Well, that's fantastic. We love that. But But before we let you go, well, we need you to plug all of your information. Where can people read your stuff, and where can they give you money, and where can they know more things than they knew before they got to hear from you?
Yeah, just LawDork, www.lawdork.com. And I am mainly on Blue Sky, Chris Geidner there, but also have LawDork News there. If you just want my I pretty much just like repost all of the just legal things. Whereas I'm an actual person at Chris Geidner, which I occasionally need to remind people of. Right. And yeah, I have free and paid subscriptions at LawDork. Virtually all of my content is available to everybody at LawDork. I do a few paid-only content things that are really, as everybody who's paid knows, more of just a tip of my hat thank you than like something big, because I really do think, especially right now, that like virtually everything that I'm writing about is news that everybody needs to have access to.
It's news you can use.
And
it really is.
Yeah, it's as little as $6 a month, $60 a year. If you can't afford it, you're helping independent legal journalism at a time when, I mean, by the day, we're getting news about like the Washington Post and its additional layoffs coming, in addition to everything else that they've already had, in addition to just everything else that's going on to harm media, and in addition to just like wanting somebody who is both very knowledgeable about what the Supreme Court does, is a lawyer by training, and yet doesn't hold back and doesn't sort of play any sort of like both sides bullshit in what I'm writing. Yeah.
We just really like with the way that our country has all these different jurisdictions and circuits and different like methods of implementing laws, and you know, all of that stuff for me is really hard to keep straight. So having somebody who can explain that is super crucial, because I'm not going to learn it. I'm simply not. So that's why I have you.
Perfect. I couldn't ask for more. I mean, but I will say the one thing I would add is that something that I am known for is that although that's like one fundamental part of what I want, is like, I want people to be able to like, to just read what I'm doing and have an idea of what's going on without needing to know all the background. But also, like, an essential part of what I do is make sure that like all of the documents are linked to, all of the filings, all of the opinions, all of the orders are there for people who want to essentially check my work. Like you think I'm like too crazy liberal, or you think I'm not liberal enough, because I get both.
Who doesn't?
Like go read the opinion yourself, decide where I'm right or wrong. Like go for it. I'm all for that. But also it's like I have a lot of people who are state and federal lawmakers, lawyers at organizations on cases, activists who are worried about what's happening, who need to see these filings. I want to be a part of educating people and providing them with all of that information, so that like when ICE comes to their town, they do know what has happened. They do know what the like successful lawsuits filed by the ACLU have looked like. They do know who the lawyers are, who they can email. And I think it is important for all of that information to be out there, like both as an accountability for me and as a tool for other people.
Yeah, that is so important. And, you know, in this last year and a half, I've learned so many new words. I've learned sua sponte. Exactly. I've learned TRO. I've learned TPS. I've learned so many things. So
Yeah,
I'm feeling so enriched.
It is quite a world. Back in the first Trump administration, when I was at BuzzFeed, my editor Catherine Miller and I had we called it a series. Here's a part of the Constitution you never knew about and never thought you would need to know about.
We love that. We love that.
Has now definitely continued. Yeah. So, but thank you so much for having me.
Absolutely.
Thank you for helping us learn a little bit more about the system and how we can navigate it to try to bring those happy days back. Because as we said at the beginning, they are coming, but they're not going to come on their own. We have to make it happen. So here we go. Everybody go. So this has been Half the Answer, where understanding a question is half the answer. Thank you so much, everybody. We will see you next time.
Thanks for listening to Half the Answer, presented by Liberal Currents. You can find Half the Answer anywhere you get your podcasts. Liberal Currents is an entirely listener and subscriber-funded publication, which includes programs like Half the Answer and Neon Liberalism. So, if you like what you've heard and wish to contribute, you may do so at liberalcurrents.com and through Patreon. And remember, understanding a question is half the answer.